Welcome and good morning to those of you joining us on the west coast of Canada, and good afternoon to those joining us on the east coast of Canada. My name is Dave Pentland. I'm with Carson International, and we are. I'm normally joined by Dan Kisselback from Miller Thomson. Dan's been called away in an emergency today, so he won't be joining us. In his place is Satinder Baines. Satinder Baines is a legal expert with Miller Thomson. He is not a lawyer by trade, but he has 20 years of practice in the customs field, previously with CBSA as a valuation officer, and then worked for two major accounting firms prior to that, to joining Miller Thomson. So before we get started, I'll just, next slide, I'll just say that information provided in this session is not intended to be or constitute legal advice or customs advice. Instead, it's information and content, and materials available are for general information purposes only. So brief bio about me. My name is Dave Pentland. I'm Vice President of Carson International. We're a medium-sized Canadian and U.S. customs broker. I'm a licensed customs broker. Normally with me, the next slide is Dan Kisselback, a partner in Vancouver and Toronto. And like I said, Dan's not with us today, but normally he is. Next, and we always like to start with a quote. So we're going to talk today about countervailing and anti-dump duties. And it's just like Bill Maher said, he finds that the world is changing much faster than even you can bitch about. So countervailing duties and anti-dump duties in 30 to 40 minutes. It's pretty much like reading Tolstoy's War and Peace, 1,200 pages in about 30 minutes. So we're going to do a high level. We're going to walk through how the processes work. And then we're going to look at a really topical case that's going on now, which is upholstered furniture. And we'll leave you some takeaways and some links that you should be involved in. So SEMA, or the Special Import Measures Act, it sets out rules and procedures for anti-dumping and countervailing duty actions under Canadian domestic law. So the act is used to provide protection to Canadian producers and manufacturers that are being harmed or injured by dumping or subsidizing duty of goods imported into Canada. And so it's very important. It starts with harm that's being levied against Canadian manufacturers. So that the intent is to protect those industries and manufacturers from imports that believed are to be injurious to the domestic manufacturing. Anti-dumping duty is assessed when it's found that the product being investigated is being sold to Canadian importers at prices that are lower or comparable products in the country of export, or when goods are sold into Canada at unprofitable prices. And so dumping of goods occurs when goods are imported in Canada at lower price than normal values. And so this is where it gets into how do you determine normal values. So generally the price that the good is sold in its home market or at a price below the total cost perceived that it's manufactured at. So Special Measures Import Act is actually, the other side of it is countervailing duty. And this is assessed and is separate, but part of SEMA is when the exporter producer has been financially subsidized by their government. So a lot of times you'll see that China is involved because China's government often will help subsidize certain products that are being manufactured within that company at a lower cost to compete globally around the world. So subsidization of goods occurs when foreign governments give financial incentives, and they're either as grants, tax incentives to producers, manufacturers that allow them to export these goods into Canada at reduced prices. And so this is just not Canada has this process in place. The United States does it, the UK does, Australia, New Zealand. Most of the WTO countries that are involved and have some kind of SEMA or anti-dump act that helps protect domestic manufacturers. So if established that the goods are coming into Canada and are being dumped or subsidized, and that the dumping or subsidization has caused injury or will cause injury, a Canadian industry producing those goods, and anti-dumping countervailing duty may be imposed by the Canadian government, which effectively increases the price of the goods to be valued, and that would have been expected to be, and there have been no dumping or subsidization. So the CVD is part of the anti-dump, and that's all part of SEMA together. So, next slide. So this flowchart is for people that like flowcharts in the government. It's CBSA uses it to describe the timeline. I'm going to spend a little bit of time on it, but I'm not going to go in a lot of detail on it, and just walk you through the process, how it starts. So the action starts with a SEMA investigation starts when CBSA is made aware by a plaintiff in Canada that is a manufacturer that they believe that their industry, or particularly themselves, are being impacted by products that are being manufactured other places in the world and coming in at what they believe is lower than what normal values should be. So that starts with CBSA only. CBSA will look at it within the first 3 weeks, and within the next 30 days, they'll take a look to decide, do they believe on the information supplied that that there's been some sort of injury caused to domestic manufacturers. And if that's the case, they will take it to the CITT, and concurrently CBSA and CITT will take a look to see over the next 60 days whether there is enough information supplied, or if there needs to be further information, that they should go forward and take a look at how this should be set up. If they decide that there is none, then no action is taken, it's dismissed. They go back to the plaintiff and either advise them that more information is required, or that the complaint has been dismissed. If they decide to go forward with it, the CBSA with CITT within the next 60 days will actually take a look to see if there's injury and at what level the injury is, and they will publish provisional anti-dump and countervailing duty rates as a specific date. And so when we take a look at upholstered furniture, that date happened to be May 5th of this year of 2021. Once that starts, as of that date, anti-dump penalties, both countervailing duty and anti-dump, can be assessed as of that date going forward, but it's still under review. And now that review can take up to 180 days, and that they will actually take a look to see if that's going to take place. And then what they'll do is they'll finalize it, and usually within 260 days, they'll actually finalize the agreement. So the upholstered furniture we're going to look at has not been finalized, but right now the provisional duty rates are in place as it is. So next slide, please. So procedure under SEMA is such duties are levied is divided. It's really 2 stages. So that flow chart just spread it out a little bigger, but really in our world, we look at the first 2 stages. The first stage, like I discussed, is CBSA generally looks at an investigation whether dumping or subsidized has occurred. So this is where the plaintiff supplies information on what harm has been caused to their specifically their company, and they take a look to see. The second stage is an economic inquiry conducted by CITT that determines whether the dumping or subsidized is actually causing injury. So the next slide. So SEMA investigation, really the process takes, like I said, 260 days from the time that CBSA receives a complaint until the CITT tribunal makes a finding. And so in that time, as we looked at the flow chart, CBSA is working in conjunction with CITT, and it's information going back and forth between the 2 parties. Where there's evidence that discloses a reasonable indication that the goods have been dumped or subsidized that is causing injury to the Canadian industry, the CBSA will initiate an investigation by sending requests for further detailed information to importers, exporters, and where applicable, foreign governments. So in this case, they will go to the Canadian importers database. They'll take a look at the trade data on all the importers that came in. The group that they reach out to is usually the top 80% of importers within that group. Everybody within that group is then notified by CBSA that an investigation is underway. This is what it's in regards to, and that if they'd like to make submissions themselves with their vendors, and certainly their vendors need to provide information, they will take a look to see if they can be granted a different percentage rate on anti-dump or countervailing duty, or if it's something that they're going to be lumped in to a group that's going to have a generalized duty rate for both for countervailing duty and anti-dump duty. And so this is a really important stage. This is a stage that often many vendors and some importers ignore, don't get back, and they don't realize that CBSA and CITT is marching ahead with the information that's been supplied to them. And if your vendors don't take part in this process, you will get lumped into a general finding, which will always be the highest rate of anti-dump duty and countervailing duty. So when the investigation takes place and they issue a preliminary determination, many times some of the vendors will now take a look and see some of their competitors or vendors in other countries that they recognize will have a lower rated duty than the general rated duty because they haven't supplied information. So the preliminary time that's taken place, you can still supply information to CBSA and CITT to try and get your vendor into a different classification. So, and this gets into really technical, and a lot of it is what CITT, and I'm not party to it, what they ask of the vendors to supply, and also what they're asking foreign governments in the way of what sort of subsidies they're supplying certain industries. So these, and then the provisional duties are based on the estimated margin of the dumping and amount of subsidies. So next slide, Satinder. So provisional duties are brought on as when the president of the CBSA determines that the margin of dumping or the amount of subsidy on the goods of particular exporter is insignificant. Provisional duties will not be imposed on goods of the same description imported into Canada during the provisional period. So in any margin of dumping less than 2%, they'll dismiss the application and of an export price, and an amount of subsidy less than 1% of the export price are normally considered insignificant. So now the importer becomes immediately liable, and in this case, when we're going to look at upholstered furniture, for the payment of provisional duties upon the importation of goods subject to the duty during the provisional period. Provisional period, in this case, in upholstered furniture, started May 5th. So for greater certainty, provisional duty is assessed on goods released on the day of the tribunal's decision, which in this case was May 5th. So, next slide. So the imported goods imported during the provisional period will need to either pay the determined amount of provisional duty, or because it's in a provisional period and it hasn't been finalized by CBSA and CITT, they can actually post a security, a surety bond to cover the determined amount of provisional duty while they're going through the process of either getting their vendor, specific vendor, to have a lower rated duty than the generalized duty, or they're still lobbying to either have exemptions on their specific products. So, and I mean, when they're determining what dumped or subsidized goods have caused material injury, the CITT considers many factors, and they look at the impact on goods and prices in Canada, profitability to Canadian manufacturers, and also market share. So those are the big things that they're actually looking at when they're trying to finalize the investigation. So next slide, please. So in instances where the CITT finds that that dumping has taken place or subsidizing is causing injury, and anti-dumping and countervailing duties will be made payable on importations after the date of the CITT's decision. The CITT finds that that no injury is caused by the dumping or subsidizing, then all provisional duties collected after the preliminary determination are refunded to the importer. So this provisional period, it's not set in stone. It's really when they're trying to finalize things. But what it's done is it's actually putting a marker in time that they don't want the industry to be flooded with imports while they're trying to finalize the exact countervailing duties and anti-dump duties that are going to be applied either on a general basis or specific specified by vendor. So the anti-dumping and countervailing duties imposed by the CITT's findings, they always expire within 5 years from the anniversary of their introduction. However, a review can be initiated before the expiry date to determine whether there's likely to be a continuation of dumping or subsidization causing material industry. So if it's viewed that a product that is subject to countervailing duties and anti-dump duties is either that foreign country is no longer subsidizing manufacturers, and or they've increased their prices to where they believe they're at normal values, they can ask for a review to be taken place, and they can actually drop the countervailing duties and anti-dump duties. Next slide. So expiry reviews, like I mentioned, they're reviewed by CT to avert that injury would be otherwise be caused to domestic industry without them. So if the domestic industry seems to have rebounded and foreign manufacturers have come in line, then the process will, and they'll let the anti-dump or countervailing duties actually expire. So it's common for the CITT's anti-dump and countervailing duty measures to continue for several years. There's some in place now. I can see on extruded aluminum, rebar, copper fittings that have been in place for a number of years, and they're always in place. And it's just the importers get used to it, and it's just a way of controlling the bad actors, as they believe. And if injury is still taking place, the acts will still, or the countervailing duties and anti-dump duties will still apply. So next slide. So before we get into this, I mean, SEMA takes place on a wide range of products. So you've got everything from aluminum extrusions in China to copper pipe fittings from South Korea and the United States, to dry wheat pasta, to refined sugar from the United States and Canada, whole potatoes from the United States. And in this case, we're going to look at upholstered domestic furniture because it's been in the news and widely publicized because it's something that hits hard and fast on the consumer. A lot of things will come in where only trade will know about it or care about it. Certainly on copper pipe fittings, the normal person sitting in his house wouldn't be affected. When this came into place on May 5th, it was widely advertised in many of the medium stream papers, and it's something that all of a sudden impacts everybody. So I know there's a number of people that have ordered furniture that have been canceled because importers could not possibly deal with the increases and still commit to what the sales price of furniture that people had ordered. So on May 5th, 2021, CBSA imposed provisional duties on upholstered domestic seating originating or exported from China and Vietnam. Those are the two named countries. So this is only China and Vietnam importing into Canada. And they're under investigation by CBSA and CITT. May 5th, very important date. Those are provisional duty dates. And the duty was either payable on those dates, or there was a bond that had to be posted for once the review has been conducted and the rates have been finalized. So CBSA made preliminary determinations under subsection 31 or 38.1 of the Special Import Measures Act that name the countries and dumping, subsidizing of the UDS entering the Canadian market. So CBSA will continue its investigation of the dumping and subsidizing will make a final decision by August 3rd, 2021. And the CITT is expected to issue its findings a month later on September 2nd. So next slide. And next slide, Satina, please. So in the brokers world, the usual tariff classification numbers that are impacted on these goods are 9401.40 through 9401.71. And so just to give you an idea, up until May 5th, if you're importing upholstered furniture from China or Vietnam, the first 3 HS codes attracted a 9.5% duty rate, and the last 2 are 8% duty. So that was the duty that was implied. And then also the Vietnamese furniture was actually covered under the CPTPP trade agreement. So there actually was a further reduction on the duty. So that was the only duty involved. And so go to the next slide, please. So those are the HS codes. However, the SEMA always says that these are the tariff classifications that numbers may be, but they may apply to goods not included in the SEMA measures. So they sort of lead it a little bit wide opening that if they believe that there is other HS codes that are part of this, they may not be listed. And it gives them the ability to go after other things if they're described but not listed in the HS code. So it's based on it's very important that you note that it's based on the description of the goods and not the tariff classification. And that's listed in the Act. So next slide, please. So to bring some numbers in perspective, so there's 2 provisional duties that have been applied since May 5th of 2021. And the 2 duties are anti-dumping duty and countervailing duty. And so if you're bringing upholstered leather furniture in from China, the provisional anti-dumping duty is 206.36%. Provisional countervailing duty, because the government is involved in subsidization, is 89.54%. So your total provisional duties is 295.9%. So just to use a leather sofa that came in valued at $1,000 Canadian, and in the past out of China you paid 9.5%, you pay $90.50 in duty. As of May 5th, the government's telling that on that $1,000 sofa, you now owe the government $2,959 in provisional duties. So a massive, massive jump that certainly the industry was not ready for and nobody could take effect. Similarly, Vietnam is a little less, but still that $1,000 piece of furniture may have cost you $95 in duty. You're now paying $1,015 in SEMA duties. So now next slide. Now specifically on upholstered furniture, if you were a vendor with your importer that got involved and supplied information and filled out the what CITT had asked as far as your manufacturing rates, your sales rates, and subsidization, you could be listed to receive provisional duty rates that are far less than the 295.9%. And so if you look at Vanguard Industries in China, they supplied information, and CBSE and CITT is decided that the information they supplied enables Vanguard not to take that 295.9% general of all exporters. They're specifically named so that when goods are brought in, they in total will pay 60.11%. So a huge, huge incentive for vendors to get involved. And like I said, the window is still open for vendors overseas to take part and provide information to CBSA and CITT if you want to be involved in having your specific company looked at to get away from that general rate that are all exporters. So if you're a vendor, you're buying from a vendor, they're not listed within that group, then you're subject to all other exporters. And it's a punitive rate that I can't believe anybody could ever bring furniture and leather sofas or ottomans into the country, into Canada, and try and make any kind of sale on it. So next slide, please. So I guess the big key takeaways are, you need to actually consult CIMA measures that are in force. And so, I know one of our next sessions is going to be talking about Canada Customs and CARM, and it looks as if there's a bit of a self-service portal to get tariff information online. Right now, you could go on and take a look at the tariff on upholstered furniture, and if you looked at the tariff on furniture, you'd still see 9.5%. You need to go somewhere else to see if there's any CIMA measures in force if you're bringing in upholstered furniture, whole potatoes, refined sugar, other items, because those are very, very punitive duty rates, and you don't want to be caught by any surprises. So that's a great website to look up to make sure that if you're importing, you're not importing in goods that are either subject to measures in force now or that are being pursued by CBSAI and CITT. There's also a great website that's under import stats of products under CIMA measures. So if there's a CIMA measure in place, it'll actually track statistics on importing and what those products are and the levels they're being imported into Canada. And then the other thing that most brokers subscribe to, and I'm sure Dan's firm does as well, is there's an email alert service that you can subscribe to that tells you when they're looking at cases, or if there's been inquiries on harm that's being done by Canadian manufacturers. There's a great website you can be alerted to. So, and I guess the bottom thing is if you're having issues with CIMA, then you need to consult a knowledgeable customs broker and or trade attorney to see if your products are subject to CIMA. There are a lot of ways to mitigate by getting your vendors involved. There's also ways through drawbacks. If you're bringing goods in, unlike the United States where anti-dump duties, you can't draw back. Canada does allow, if you sell those goods from Canada back in the United States, you can actually sell them into the US and recover on a drawback any CIMA duties that you paid. So there's a few ways to mitigate and lower the CIMA duties, and certainly it's best to take notice that CIMA is one of those things that you need to really get involved, look specifically at your product, and get a lot of information. I often find that the contacts that are at CIMA that are involved in the specific products being imported, they're very, very knowledgeable people. I would actually caution you to stay away from most CBSA trade officers, because that is not their area of expertise. The CIMA group, they're involved in it. So if we have questions and issues, we definitely go to that group. So again, I'm gonna sort of wrap things up. Hopefully I've given you a high level. If you want a copy of the presentation, you're welcome to ask for it. I'd like to thank Sadinder for jumping in Dan's absence and pushing through the slides. If you have any questions or comments or suggestions, on the next slide is on my email and Dan's email. You can certainly drop us an email. And I just want to thank Miller Thomson for setting this up, and look forward to talking again on topics near and dear to the supply chain. So thanks a lot for your time, and then enjoy the rest of your day. Bye now.